Welcome to a new edition of the Florida Appeals Journal. I'm Jennifer Carroll, and we try to address very important issues of procedure and substance that all litigators can use in their practice. Today, we're going to talk about a writ of prohibition, one of the many extraordinary writs, but a very special writ. That's almost one of my favorites. It's one of the least understood. Again, as with all extraordinary writs, you're going to go by Florida Rule of Appellate Procedure 9.100, which governs the procedure that you'll follow on filing the writ of prohibition. But the question is, of course, when do you invoke the writ of prohibition? When does it apply? And then we'll get to just the how-tos. Well, the writ of prohibition is supposedly preventive. So in most cases, it's going to be you're trying to prevent further action taking place in the trial court. Okay, so it's defined as the process by which the superior court, so you're going to have the appellate court, is going to restrain the unauthorized use of judicial power by the lower tribunal. So it is a preventive remedy and not corrective. Sometimes the lines get blurred, though, depending on the particular case. But it has to be filed before, as a general rule, the improper exercise of judicial power has caused harm to the petitioner. And again, just like with the writ of mandamus, if you've got another adequate remedy available to you, then you cannot invoke the petition for writ of prohibition. And of course, it's never a substitute for an appeal. But again, it's allowed only as a matter of the sound judicial discretion of the court, not a matter of right. Okay. Now, you can use a writ of prohibition to restrain lower court's improper exercise of jurisdiction. So if the lower court thinks it has jurisdiction on a case, and your review of the law is showing, well, no, you don't have jurisdiction over this particular case, then you can do, and that's really a classic use of a petition for prohibition. You file your petition for prohibition saying, hey, the trial court should not be moving forward on this case. There's no jurisdiction. So that actually can come up quite a bit, but that's the extraordinary writ you're going to want to use. And when I'm addressing these kind of, I'm trying to address really the most common, most popular writs that are often used in really everyday practice, that these often will come up in your normal litigation caseload. So you definitely want to keep these in mind, and especially on prohibition. Now, there's another very special function with a petition for prohibition. This is the writ you use when you've got an issue involved on the disqualification of a trial judge. Prohibitions can be used to review the denial of a motion for disqualification in the lower court. And your argument is, hey, this is going to cause harm that cannot be adequately corrected on appeal. So you will want to bring that right away. But that's the particular one, the particular writ that you're going to use for that purpose. Now, as with the other writs, you're going to go by, like I said earlier, Rule 9.100 on original proceedings. Now, and let me just go over some of these points. Again, I think most of you know this. You're going to invoke it by filing a petition, which is like a brief. You can find forms everywhere for it. But you file that, and you're going to file an appendix. You don't file a record, okay? And again, you're not going to you don't put the judge's name in the caption, but you will put it in the body of the petition. And you can serve a copy on the judge, the trial judge. The judge is, of course, not required to respond. The judge may respond, but most of the time, 99.9%, they don't respond. And they just say, let the lawyers fight it out. So you can have lawyer on the other side, or maybe you have other your defendant, you have other defendants, they can go ahead and file too against your position on the petition. So again, you go by, that's under 9.100C. And what's special about, I always thought this is special about the petition for prohibition, is if you get an order to show cause, that's a stay. So you don't have to do your motion for stay of proceedings as you would, so with some of these other petitions. You get the order to show cause, and then that stays the proceedings in the trial court. So, order to show cause, hey, you've stated some type of prima facie case, you've got the interest of the appellate court. They think, hey, there may be an issue here, so let's get a response, and they'll order a response from you. Now, what's also special, well, really with prohibition and some of the other writs, except cert, is time limits. So, petition for cert, you've got 30 days. But prohibition, you don't really have that time limit. But you still have to remember, you got to be operating within a reasonable period of time. And if it is a situation that you feel is going to harm you if you move forward without doing a petition, it only makes sense. You're going to want to move as quickly as you can in the case. So remember that there is no time limit on the prohibition. But if you wait too long, the court may deny your petition really on that ground alone. Now, there are 4 kinds of original proceedings that are subject to a jurisdictional time limit. And you've got the petition for cert, of course, and there's a petition for review of non-final administrative order, which could be under quo warranto. You've got 30 days on that. You've got petition challenging an order of Department of Corrections in a prisoner disciplinary proceeding, that's 30 days. And I believe, let me see, we've got petition to review quasi-judicial action of agencies, boards, and commissioners, local government. And so you have 30 days. But other than that, the rest of the petitions, and including petition for prohibition, you don't have that time limit. And if you, I would refer you again to really know the rule 9.100 for the procedure, and find out that sometimes on some of these there's a fee, on some there aren't. So if you have any further questions on this invoking petition for writ of prohibition, by all means let us know, and we can address those questions in a future edition. Again, thank you. I hope this is helpful in your practice, and we'll see you next time. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.